So I'm sorry to be the sort of forceful moderator, but I wanted to make sure we got some time for audience questions, because I always find that the wisdom of crowds is very important in all of these, even a small crowd. And so without further ado, I will have, we'll start up today, and our format for today will be, each of the panelists will give sort of an initial statement. I mean, it can be up to 10 minutes, it could be less, et cetera. And then we'll open up to questions, and then I also have a list of questions that we have prepared in our before, so I can get into those questions as well, to sort of get people to talk directly to with each other about particular aspects of health privacy. We've got sort of bios in the book, so I won't go through that. And with that, we'll go with Bill, Laura, Bill, and Beatrice. So first up, Bill, would you like to go?
Thank you. Thank you very much. I come to this subject from both the standpoint of a clinical researcher, a Washington policymaker for a number of years, and now a professor over in West Virginia. Look back for a second here at just the political context. There's two things I noticed in all my years working in the Senate that always made an impression on new health staff. And the first one was the absolutely Byzantine nature of our healthcare system here. You could only call it a system in the sense of a Rube Goldberg type device, I think. But the second thing that always amazed folks was the absolutely long and excruciating path to ever get legislation enacted. When I arrived in Washington, the first thing they gave me to do was to work on the Genetic Information Non-Discrimination Act. In 2008, after being here 5 years, we finally enacted it 12 years into the effort. That experience really taught me a lot about the policy making and how law and policymaking respond to advances in science, and that fundamentally is an issue here. Regardless of, I think, of your training or experience, all of us recognize that technology is value neutral. Nuclear technology, for example, can be life-saving or it can be lethal. And so government has a rational and appropriate role in regulating technology. As we're discussing health privacy this week, put that into the context that we wouldn't be here were it not for the advances in information science. I don't think we'd be having this conference. Information science is what's driving the issues that we're confronting. The fact is, technology is facilitating changes in behavior. And as it's done so in the United States, our HIPAA statute has actually reflected a partial retreat back from our ethical foundations. If you go back, whether it's the Hippocratic Oath, the Nuremberg Code, or the Helsinki Declaration. Politics, though, synergizes with that technology to affect those changes. Today, individuals, especially here in Washington, are viewed as consumers, while the predominant influence in legislation, especially after spending 7 years here, is the so-called stakeholder concept. But those are largely those in the health sector who profit economically and wisely divert some of their resources to ensure their continued influence. But as has been noted, our perspective on privacy also has influenced the current American statutory standard. Some argue that our views are rooted in dissent, and that our orientation towards privacy is largely skewed by that. We hear some insist if you have nothing to hide, privacy shouldn't be a major concern. You can hear that from business leaders ranging from Eric Schmidt of Google to law enforcement, security agencies, even your own neighbors. So you hear these disparaging statements come out regarding privacy advocates, and I hear it all the time in the Hill about the black helicopter crowd. It's really good dialogue for a Hollywood conspiracy film, but it misses the fundamental importance of privacy. And as was just mentioned, in terms of the Hill, when we talk about privacy, the case that always comes up is Griswold v. Connecticut, which tells something about our orientation in privacy, that justices were considering and arguing an inferred right to privacy, which would block government interference in married couples' access to contraception. When you look at that landmark case and then you look at the European orientation, I think you see a big difference. And I'll assure you that there's many still in Congress who still do not believe that privacy, fundamental right to privacy exists. The fact is, the EU has recognized a fundamental human right. And while we instead follow a more political and a route of political and economic expediency, is I guess how I would phrase it. And that's how we wound up with all these legal inconsistencies and contradictions that we face today. The EU concept privacy seems to me to be much less strained and much less compartmentalized than our own. The Data Protection Directive of 1995 recognizes a fundamental right to privacy and personal data. That doesn't preclude legitimate and explicit uses, and it doesn't compromise the public interest. But it does place the individual first and creates a burden for government and commerce to justify access to information. Last year I described a standard for health information: need to know rather than want to use. That's a critical distinction, and with the EU recognizing a limit on specified, explicit, and legitimate purposes for personal information, I think that's an important distinction, and it lines up with that objective. But U.S. laws really focus more on expediency and towards business interests. And in a nation where we had a presidential candidate a while back talk about corporations being people, we balance commercial interests with individual rights, and I think that's a fundamental difference. So even after our 2009 revision, and I was always told we couldn't tear HIPAA apart, you couldn't confront any revisions or reforms to HIPAA, we still have very weak restrictions even on the marketing use of personal health data. We've been sold a big data promise, as we've been hearing today, of linking disparate databases for massive mining efforts. But at the same time, we're told our health data can be safely sold as long as it's de-identified. The identifiers are removed. I don't think I need to point out there's a technological conflict there. If you can do big data, you can link up this data and you can re-identify it. It just doesn't add up. The EU's proposed regulation acknowledges scientific reality, I think, in directly addressing the combining of information to re-identify individuals. But business interests wish not only to combine those disparate databases, but even access personal health data directly with no restriction whatsoever. And a quote that I just recently used in the HHS omnibus rule that came out just early this year, and I'm quoting from HHS, commenters generally agreed that a covered entity should be permitted to disclose protected health information without individual authorization as required by law, and even if remuneration is received in exchange for the disclosure. That's basically Katie bar the door. You take your data, PHI, no de-identification, sell it for profit without consent. We had 44 distinct entities commenting on the final rule, and you can imagine the distribution of those entities. Now, government itself does have a compelling interest in some forms of access. These include law enforcement, I think we'd all agree, national security, and the ability to address serious and imminent public health threats. And those I don't think appear compromised in the EU. Yet in both the US and the EU, the desire of both the public and the private sectors for health information has given rise to some schemes of questionable wisdom in which the presumed economic benefits trump consent. We've gone to a point where expediency seems to rule. I mentioned a little earlier today, the HIPAA public health exclusion provides a blanket exception for virtually any use whatsoever. That can be PHI, it can be sold, it can be purchased for profit. I know some envision in our system the engineering of a healthier society if only we can reach into the individual's health records and perhaps some kind of other information, including your personal behavior. That ultimately produces an outcome which we track, we incentivize, and we punish health behaviors. I heard that when we were writing the health reform bill. There were those on both sides of the aisle arguing that we should institute that sort of system. And that's really the engineering of humans. We're really talking about some fundamental human rights there. To paraphrase from the movie Jurassic Park, I always think of Jeff Goldblum, just because you can do it doesn't mean you should. Consider this situation as a clinical scientist. Just in the last few weeks we've had news come out about maybe we were wrong about our advice in terms of recommended sodium levels in one's diet. Now, 5 or 10 years ago, we decided to implement some kind of a system in terms of penalty or incentive for how a person eats or what foods they consume or what we want to monitor. That's the kind of outcome we can wind up with where, as one who's been in clinical investigation and health policy, I think we need to take some great caution before we embark on those kind of paternalistic schemes. Doesn't mean we can't. We've got to think our way through it. The situation in front of us is that technology really allows us to influence and even compel behavior. You could put a cattle prod in the driver's seat of a car and together with a GPS, we could all ensure that everyone drives the speed limit. But that creates a very different sort of society. And giving the susceptibility of government, I know we've had a lot of scandals in the news here in the United States the last couple of months, to different kinds of influences, whose rights and interests are going to be prioritized in that kind of an invasive system. As some have heard me say for the last year or so, that to me the word privacy, I think, skews the public's concept of what we're talking about, because there are greater impacts simply than my sense of self or sense of intimate life, and that is really the facilitation of discrimination, as we were touching on a little earlier in terms of data mining. Discrimination can be great. It can mean I can identify a cancer treatment that's highly effective, but it also means civil rights abuses are possible too. So I learned as we were working on genetic bias that there's immense creativity possible in devising these schemes. Charles Duhigg was referenced earlier, and in terms of what he indicated that Target could do, it really raises some fundamental questions about the future of HIPAA. If you can derive data outside of covered entities, and that's not protected, and it can become a surrogate for data, and we can even merge that into different forms. I may have a group that's 80% Hispanic women. It's not a surrogate for being Hispanic or being female, but will that be protected under current civil rights law? Most tell me no. So the construction of those kinds of things is a real concern.
So I think you've got 1 minute left.
I've got 1 minute left. I'm going to wrap in a minute here. We have a context-dependent system. So it's no surprise to me that 58% of Americans don't think it's protecting them under the HIPAA regime. There's two questions that have been put before us here today, and the first one is, or the second one I'll answer first, is whether U.S. firms should comply with EU standards. It seems to me the answer to that is yes, and it's indisputably yes if they're serving EU markets. I'm worried that our government is instead going to try to harmonize law such that the EU standard and the proposed regulation is compromised. The first question, though, I think is a little simplistic and maybe unrealistic. We're not going to do a wholesale adoption of EU standards. The U.S. is always going to want to do its own. But I think that what we're looking at is the fundamental underpinnings in terms of right to privacy, in terms of privacy of data being collected, being used for that specified purpose unless there's consent. There's some foundation there, I think, that we can work from. And there are perhaps some principles that we can look at in terms of harmonization. So I'm hopeful that we're going to have a broader legal examination in the coming months and maybe a year or two that's going to work us closer to that.
Oh, great. Thanks so much, Bill.
Thanks.
It's great. And next up is Lara Ballard.
Yes, thank you very much. And that was really, those were some fascinating opening remarks. I would say Bill has really made a very compelling case for what he sees as a need for change in U.S. law. I work for the U.S. State Department. I'm the Special Advisor for Privacy and Technology, and I'm the first of my kind. I mean, we just kind of made the title up because it looks cool on a business card, but what it turns out to be in practice is that I basically, for a living, argue with Europeans about privacy. And it's a really sweet gig. I would recommend this way of life to anybody, because first of all, these are not like real conflicts, okay? Syria, that's a real conflict. I mean, you know, North Korea getting nuclear weapons, that's a conflict, okay? This is like a couple of college roommates arguing over whose turn it was to buy toilet paper, okay? You know, like we're all among friends here. You know, we do seem to argue about Google and Facebook quite a bit, and I think that's to the discredit of the dialogue as a whole. I represent the United States of America. I'm not the United States of Google and Facebook. You know, they have their own lobbyists. They seem to have found their way around Brussels all on their own. They probably know more what's going on than I ever will. You know, they can take care of themselves. The U.S. does engage in privacy dialogue with the EU, often over wine, which again is just delightful. There's just free wine. The wine is always free. I don't think I've ever purchased wine in Europe. It's just always there. It's fantastic. But you know, the United States government is really after larger interests here, and one of our core interests is really about the free flow of data. Now, a lot of that is for reasons of commercial interest, that's without a doubt. But free flow of data is actually important to both the U.S. and the EU in a wide variety of contexts. And Bill alluded to public health. Public health, managing public health emergencies, SARS outbreaks where somebody gets on a plane in one continent and lands in the other. These are the kind of areas where we really have to have free flow of data. So the U.S., the U.S. has given testimony about the EU framework, often at the EU's invitation. I mean, I see David Vladeck out here. David and I used to work together when he was at the FTC. David testified at a European Parliament hearing last October at the invitation of Jan-Philip Albrecht, who is the special rapporteur for the European Parliament. So whatever our differences with the Europeans on privacy, they keep inviting us over. So, they must, and they keep pouring the wine. So, we must not. They seem to think that continuing the dialogue is important. And again, this dialogue is longstanding. It goes at least back to the 1970s, probably even earlier. The U.S. and Europe worked together to formulate the 1980 OECD guidelines on the protection of privacy and the transborder flow of personal data, which have been incredibly influential in the development of numerous laws. And we recently worked together again and are finalizing some major revisions to the OECD guidelines that I'm hoping will be out in July. You never know, deadlines slip, but this is an area where we have come together in common cause. And the dialogue that we do have with the EU very much is along that vein. There's an awful lot of cooperation between privacy regulators. Peter Hustings, who, I understand, he gave a keynote address this morning, right? Speaks in very positive terms about the cooperation that goes on between the FTC and numerous EU regulators. A lot of improvements even in the past several years about cooperating to bridge that transborder gap. So there really are a lot of positives. Now, as to the specific question posed by this panel, which is, as Bill says, should U.S. companies meet EU requirements? I mean, we had a lively email discussion about that because I wasn't quite sure how to answer the question. I mean, if the question is literally, should a U.S. company doing business in the EU adhere to EU law? Yeah, I think that's probably that's a good idea. But I think the question is getting at, should we transplant EU law into U.S. law to resolve some of the problems that Bill is alluding to? And there, I'm a lawyer by training, and so part of what I do when I examine a question like that is to unpack the terms. So first of all, what do we mean by U.S. company, and then what do we mean by EU requirements? U.S. companies, the British Bankers Association has a position paper on the EU regulation that I think reflects some views of the U.S. banking sector. So, as an initial matter, I'm trying to figure out what is a U.S. company. I mean, these are big multinational companies that have many tendrils in both the U.S. and the EU. So again, they're going to lobby in Brussels, they're going to lobby in Washington, they're going to do what they're going to do. They'd be just as happy to lobby against me if I said something they didn't like. Insurance Europe, another one, very closely aligned to some other views that we've seen from, U.S.-based life insurance companies that have multiple operations throughout the EU and, have position papers on the EU regulation, have transborder data flows, have a reinsurance industry, all sorts of thoughts about consent, and I think there's a pretty robust data flow going on right now pertaining to health data. See, these are life insurance companies. They're in the business of predicting how long we're going to live. And if the fact that I posted on Facebook that I saw a Broadway show this weekend gives them some indication of how long I'm going to live, I'm pretty sure they would use that if it's legal to use that. But, the issue of transplanting EU law into U.S. law, it's an interesting one. I took a course in comparative law when I was in law school, and that taught me just enough to know that comparative law is a specialized field of study that I'm probably not licensed to practice. But, one of the things I did learn from this course is that you have to look at law in sort of holistic terms. I'll even use a medical analogy. Let's think of the human body. I mean, I think what Bill is saying is that, the U.S. body of law is sick. It needs a liver transplant of some sort. But will the EU liver necessarily work in the U.S. body? I'm not sure. I understand they have to be a pretty good match, and you got to have all sorts of things to suppress the body's natural inclination to repel the foreign organ, and I could see that happening here. So this is why we have such interesting dialogue. Right, and so in our email discussions, I said, well, guys, what do you think is the defining characteristic of the EU approach? And I think what you came down to is the omnibus approach. There is one data processing law that governs everything. What we have, particularly on health data, is HIPAA. And HIPAA really does pertain primarily to healthcare providers. I used to advise on HIPAA for the State Department, so I kind of know this stuff. Yeah, it's governing health providers, and it probably isn't hitting some of these sort of cross-market sharing of health data that probably goes on in the life insurance industry. But, there are a lot of reasons why Europe took this omnibus approach, and I think chief among them is that this arose in the context of continental civil law traditions. We are a common law country. We have an awful lot in common with the UK and Ireland, and what's interesting is that there's a robust conversation going on within the EU about the EU's proposal, and a lot of the big objections are coming from the UK and Ireland. Because I think they've consistently had trouble reconciling this common law tradition with continental approaches. So a lot of what we're doing, what's going on between the US and the EU, I would not at all characterize as an attempt to weaken the EU standards. I think what we're trying to address are a lot of these differences in legal vocabulary that makes it very difficult to reconcile our approaches with theirs. Even when they're similar in intent, they look very different in form. And even lawyers who are trained in one tradition, I have a few friends who've received legal training in both the common law and civil law traditions, and they'll say, even as law students, you can tell that the training is different. The way that we analyze problems is different. So, this is a lot of what I do, is try to bridge this gap, and I'm coming to the conclusion that the differences in legal culture are as important and maybe even more important than the differences in privacy culture. And so you have to look at, before you borrow an EU law, like an organ donation, and stick it in the body of US law, you really have to think about how that's going to function within the whole body. And so I think there's an awful lot to commend the EU approach. I mean, there's a lot to commend the European approach on a lot of things, starting with the wine, but
that goes well into the body, right?
I think it's helpful if you see something wrong with U.S. law. You do, at the end of the day, have to articulate that in the U.S. manner. You have to sell it to the U.S. Congress in a way that appeals to the U.S. Congress. I wouldn't go around the U.S. Congress right now with a talking point that says, well, we should do this because this is how the French do it. Knowing what I know of the Tea Party people, that doesn't sell too well. You've got to make the case to Americans in the American way and find an approach that emphasizes the results that you're trying to achieve, the concerns that you have, and you have some very real concerns. And the EU model is certainly helpful and enlightening, but, again, you have to look at the end results. If I could say one shortcoming of the EU approach, which, I welcome further elaboration, is that sometimes we see a gap between what it looks like on paper and what actually happens in practice. And what I often see in practice is this, sometimes, the regulators can't enforce everything against everyone all the time, and they will often, how they choose who to enforce an action against depends on resources and interest and a variety of other factors. So I don't know how much attention they actually pay to health data qua health data versus other things that are concerning them, like whatever Facebook is doing, whatever Google is doing, Google Buzz, all that kind of stuff. So, I think you also have to look at what is the end result that you're aiming for. Yeah, okay, all right, I'll leave it there then.
Okay,
yeah,
great,
okay.
Great. Thank you. Well, thank you so much. All right, so we've got our tension building. By the way, if you want an example of a naive argument for the French approach, check out my 2010 article, Beyond Innovation and Competition. I say the French Canil has privacy just right. So, but that didn't go anywhere, so Laura's...
Very cool. I have a tremendous amount of respect for the French Canil. I would say that those guys have an awful lot of technical expertise and resources, and actually work quite well with the FTC. I mean, we're actually working with them on something related to the EU's system of binding corporate rules and the APEC, the Asia-Pacific Economic Cooperation cross-border privacy rules, to see if we can make those interoperable. So they're actually, I have nothing but nice things to say about Canil, actually.
Terrific. Well, great. Well, next up, we'll have Phil. Great.
Hi there. Need a microphone, maybe?
I don't know, I can shout and everyone hear me?
No, please. We've heard enough.
There we go. I'm Phil Booth. I'm campaigning actually in the UK, so mine is going to be a particularly UK take on the EU data protections about which we've heard. And I think I'd like to pick up on what Lara was saying very definitely in terms of the actual implementation. We've heard some great things about EU data protection on paper, in theory, but the practice of it is oftentimes very different on the ground. And in many ways, and I don't actually think I agree that it's in the culture of common law versus civil law, it's the agenda of a government, a bureaucracy, long-standing policy agendas which seek to root around or find the gaps, loopholes if you want to call them, that and rely on the fact that the culture that has developed in certain countries around what are in principle very good data protections is itself quite sick. Poorly enforced, poorly regulated regulations, where you've got an under-resourced information commissioner, is what it's called in our country, who can't handle more than a tiny fraction of cases, starts to recommend to me and some of my colleagues the idea of redress for the individual being maybe a thing that we'd quite like to look at. So you're looking at the American notion of redress for individuals in a case of harm. That's got some merit to it as well. Anyway, as I say, the EU DP approach is grounded, as we've said, in fundamental human rights. I think that is the principle that I think is unarguable. Yeah. How that arises in your culture, and obviously I don't understand about, having sat through a very fascinating hour before this session, American constitutional law, but I think it's unarguable that this is data about people in their lives. We're talking about data that will have an effect on someone in their life. This is what their health is going to be, well, the course of their health determines the shape of the data, but their health is also determined by the shape of this data. And we had quite a thought-provoking little exchange about where things have gone devastatingly wrong. I don't know if enough context was given this morning. The basis in European law, which pre-exists the formation of the European Union for human rights, is the European Convention on Human Rights, which came about after the Second World War, where a nation state went rogue and did appalling things, including experimenting on living human beings, destroying human beings. Yeah? And nations got together, including America, and agreed at that point that there was, there were fundamental human rights. Now, however you interpret those into your own legal system, I think it's something which people will feel in their lives and are going to increasingly feel as the Facebooks and Googles and 23andMe's and all the various other sort of companies that are emerging now, still in the very, very early stages of the internet, as someone pointed out, I think earlier on. We're talking about 20 years of history here, not 100 years, not 200 years. Yeah? This is something that we have become accustomed to. Going to a place, maybe a place is the wrong way of putting it. Having a privileged space with your doctor, a place where you can go and share secrets or private information with someone, put your life quite literally in their hands, and for which you need a reasonable expectation that that information is not going to be shared if it might cause you harm. Yeah? We're not talking about, and some people I think sometimes characterise the European approach as being very absolutist. Yeah? It's a fundamental human right, therefore everything's sort of locked down. Well, this is not the case. Yes, it's a human right, but it is something for which there are, or can be in law, exceptions. They must be necessary exceptions. They must be proportionate in a democratic society, and they must be clearly stated in the law. But there's clearly reasons why for matters of public health, like you say. This could not just be passed around within a nation, but between nations. As you say, as we move around the planet more and more, we need to be able to pass information around. That particular purpose, though, is not to open up a channel for all sorts of other purposes. And I think that's one defining feature of European data protection, as we understand it anyway, that data is gathered for a particular purpose, and that purpose is clear. And when we're talking about health data, the context in which this data is being gathered is for your health. You aren't just handing this stuff over willy-nilly, you are doing it for a particular reason. This also opens up, I think, the side of things which is very important to us at the moment in the UK, this whole issue of consent. It's quite reasonable that you are giving, if you like, implied consent for your doctor to do things with your data for your direct medical care, and maybe for your doctor to have to pass it to someone else to serve the purposes of your direct medical care. It's less reasonable, and I think these are the things which need to be articulated, listed and controlled, are secondary uses. So let me paint a picture of what's going on in the UK just briefly at the moment. The reason why we are campaigning is because the government has decided essentially to monetise the NHS data set, explicitly so. David Cameron says it's just a waste. We've got the whole of the NHS, that's the entire population's medical records, conveniently, now all computerised, sitting on GP computer systems. We will suck that up and start using it to stimulate economic growth. Okay? That is even possible under European data protection, the EU DPD, so it's not actually European data protection, it's the UK's transposition of the directive, the 95 directive, into British law, shows that there are, as you said, still some serious problems to be ironed out here. I don't want to go into it too great a detail, but just to give you a couple of examples why I think this is actually important. And okay, these are early days in the fight that we're having. As patients in the UK are discovering what is going on, and this is only literally starting to come to light now, so we're talking about a few months, not the many years that you've had of data being sold and otherwise abused, we are already having people who have had this presumption that their relationship with their doctor was confidential, starting to withhold information or simply refuse to see their doctor. And this is the risk that I worry about. If you don't get these protections right, if people cannot trust the discretion of their doctors, working in a context where, yes, everything's going, we're using more and more, creating more and more data, there are more and more things that we can do. But if you cannot trust the discretion of your doctor because, the system is just not designed that way, or the law does not permit that level of confidence, then people are, it's not a theoretical risk, people are going to withhold information and people are going to come to serious harm. So I think it's urgent that we do work this out and we find a way to align, between the US and the EU and UK, obviously from my personal perspective. But I think you're right. We need to find the really core principles of what's going on and what needs to be done, and then how that actually gets articulated within our own legal systems. I think it is very simplistic to look across the pond and say the grass is greener over there because you've got something that we don't have, and think that that's going to sort your problems out, even were it practical to do that. I don't think that's the solution. And I think we've all so far said that the second question, the bit about should US companies comply with the, that's what you do. I don't think there was any hesitation in my mind. If you come and do things with data in in the EU or with EU citizens' data, then of course you need to comply, and that's what Safe Harbour, as I understand, is about. So, thank you.
Wonderful. Thank you, Phil. Great. And we'll have Beatrice next.
Hi, thanks a lot. I feel really privileged to be on this panel because I'm the only non-specialist here. My name is Beatrice Covassi. I work for the EU mission here in DC, and I cover pretty much everything which is digital related. So my primary everyday job is not so much to argue with Lara, although I would love to. But we can do it over dinner, maybe. But it is rather to see, and that was a new position created, to see what the digital economy entails, and to try, to cover pretty much everything. Nowadays, it entails everything, so from e-health to cybersecurity, just to give you an idea of, of what's my portfolio. But I was very thrilled when Deborah asked me to be here. We met at a privacy conference in Arizona some months ago. And I think the same things that struck me at that point remained, a leitmotif of what I heard in this morning conversations. And I have to say I feel privileged also because, all my points have been mentioned by the previous speakers, so, I will not dwell very long on them. But I wanted to start, from things which are pretty banal to all of you and have been mentioned, but are fundamental in our body, and to take the physiological or anatomical, comparison. One is concerning, about what data, here very often in debates you listen about privacy, people talk about data in general. But what we're really concerned from an EU standpoint is personal data. So the word personal is very, very important and quite crucial in the whole, is underpinning the whole concept of our legislation, which means data which are, directly or indirectly, linked to a natural person, so it's personal data. And last week it actually happened to me for the first time in my life. We lost, my personal laptop, the iPad, and the camera, all with pictures that I unwisely did not put in the cloud, and on devices which I very unwisely did not put on tracking, and suddenly, the word personal data appeared to me in, with a very different, in a very different light, and with very forceful meaning, because for sure, it's not the value of a laptop, but it's the value of your own data what really matters. Another concept, which has been stressed already by previous speakers a lot, but it's fundamental. And if you paid attention to this morning conversations for those who were attending, you could really listening carefully, see that the narrative is very different in terms of, discussing about consumers or discussing about citizens and individuals. And, this is not so maybe disturbing in the general debate, to me at least, but when it comes to health data, I think it's a bit more disturbing in the sense that, or shocking if you want, in the sense that, when I'm going to the doctor, I'm not a consumer. In my view, I'm a patient. I'm an individual who needs treatment and has a problem and goes to a physician, but I'm not buying shoes the same way I'm buying pacemakers. It seems to me that there should be a different narrative around the health data in particular. And it's true that after Lisbon, we do have a much greater stress on fundamental rights. And this is something which, again, may seem pretty banal, but is to explain a bit better also what's going on in the European Commission, but the fact that before the Data Privacy Directive was part of DG Internal Market, so a directorate called internal market of the European Union. And the mission of this directorate was, free flow of people, goods, and and data in the internal market. Now, the directive is taken care of in a different new directorate which has been created, which is justice, which resounds differently and explains, if you want, visualizes the shift between a purely internal market logic, where we're thinking about data as a, in a more commercial term, to a fundamental right, citizens' right logic, which has, of course, some implications in the way, that sensitivities have gone up, have risen, if you want, also in the European Parliament, and why, Article 8 of the EU Charter also gives the Commission new foundations, and we have new legal foundations in the treaty to deal with data protection in this sense. Coming on health data, as I was mentioning before, something else which was striking to me at some point this morning was a suggestion, I can't remember by whom, that there may be some health data that are more sensitive than other health data, And again, the EU approach is no, all health data are sensitive data. And under the current legislation, we have stronger guarantees set in place for sensitive data, including, sex life, sexual orientation, health, religious beliefs, etc., so on and so forth. But it's not that I think you could come to a point to say, well, if it's about my liver, it's less sensitive than about my mental health. It's all considered worth of specific and special protection. And this is why, in this field, the notion of consent, which has been stressed a lot already, it's even more paramount than in other fields of data privacy. And it's clear that this consent, can be sometimes limited by reasons of public interest. And I was really shocked by what you were saying, because one of the current problems, and we can discuss a bit more later, but is the fact that in the field of health, member states retain a huge amount of discretion. So the possibility of having derogations based on public interest of specific member states led to a situation where there is a certain degree of fragmentation in the way that the directive was implemented, and that I was not aware that the UK could, propose
frankly, the EU,
such a measure.
The UK wants EU protection.
It's quite, it's quite shocking. And in fact, in the new regulation that we are proposing, there will be a greater emphasis on harmonization, and trying to avoid this fragmentation in the health data protection rules. And the last thought that I had, and again it was very much related to all conversations, and because of where I come from, which is the digital environment, is really about the online environment. Now, of course, in the online environment, and with the developments that you see of websites, providing health and information, etc., it is much more difficult to put boundaries and much more difficult to have this, consent in the same terms that you would have it with your doctor or with a face-to-face physician. I think that what we have, of very positive, in my view, is the e-privacy directive, which has been which is a directive covering, privacy in electronic communications, and which has been updated in 2009 to guarantee that in terms of tracking, cookies, whatever are the little traces that you leave behind in the digital world, there is your consent. I mean, you give your explicit consent. So you cannot be tracked without consent. You cannot be tracked any longer. You cannot be, you cannot have mobile applications that follow your behavior without consent. And I was very reassured by a recent speech, I mean, of FTC Chairman Ramirez on Do Not Track, where it's clear that also on this side of the pond there are really, same efforts in this direction and trying to enhance both standardization work, but also, I mean, protections in that respect. So in the online world, it seems to me that the better safeguards apply to, maybe not just to health, but cross-border to all providers. And finally, to reply, to the questions, well, if I were a big multinational company, well, I think I would go for the higher standard, because if I comply to the higher standard, well, the lower standard is automatically protected. So that would mean, my maybe naive or pragmatic take. But certainly this dialogue, and sometimes very animated dialogue, both sides of the Atlantic, is due to continue. And maybe health data is one of those areas where we could find, because they're sensitive, because citizens are particularly attached to them on both sides, maybe it's one of those areas where we could find more common ground.
Fantastic. Thank you so much to the panelists for some great openings, and I just, we now have 10 minutes, so rather than go into, I have questions that I would love to ask the folks on the panel, but I'd like to give the audience a chance. So any questions for the panel? Yeah.
My name is Peter Boersma. I'm the Councillor for Health at the Netherlands Embassy. I have an even broader portfolio than Beatrice. But my question is actually, the question here is put forward, does the US need EU type protections? And I more or less understand that the answer is no, because create an uproar here that the Americans would take off the EU requirement. But my question is there also in the content of these provisions something which would not fit into the US situation? And the other question would be, what is in your view the main obstacle to have stricter privacy rules? Is that the lobbying? Is it the functioning of Congress, or both? Or are there any other factors playing a role?
Go for it.
Just one key comment there. We all often talk about our law being context, particularly with HIPAA, context sensitive. And when I think of the word context, that's the flaw. That's one of the flaws that I see that's better in the EU approach, is that we're not playing whack-a-mole with every iteration that someone can dream up, having to come up with a new legal addressing of that. So there's a broader approach. But the other side of context is that in the EU, you're talking about a context in which the data can be used. That, I think, is a fundamental conflict, is that we allow much broader use of data. And this limitation is, to me, it's tremendously appealing, because then that brings up, as Beatrice mentioned, the idea of, if you want to go outside of that, get consent. And that is, I think, a concern to a lot of Americans. But I think that context issue is a major source of conflict.
If I can, let me follow up on that. Yeah, sure. So you're right. This really goes to the core of a lot of the privacy dialogue that has gone on between the U.S. and the EU. Now, without a doubt, again, you have industry players that have a huge amount of money riding on how consent turns out, and whether it's opt-in or opt-out, like that's money in the bank either way. Okay, but what the dialogue that has gone on between the U.S. and the EU has really been between a selected small group of real, like, hardcore privacy geeks. I mean, and this idea that is in the Obama administration's privacy and innovation blueprint is really the brainchild of Danny Weitzner, who's this brilliant MIT scholar. Okay, so respect for context, really, having argued with Europeans about this, I can see where they see this as squishy. You know, where Danny is seeing it as something that makes consent more meaningful by viewing it within the context of the relationship and saying that relationships have different contexts. The example that Danny always talks about is the example of when you purchase a product on Amazon.com. You should know that if you purchase that Amazon has a shipper who needs your address in order to ship that to you. And what he's saying is you don't need explicit consent for that. You would actually be better served by focusing on the consent to uses that are actually meaningful to you and not implicit in the relationship. Now, what's interesting is that from our perspective, we have a great deal of difficulty with these terms, legitimate interests, as it appears in the EU regulation. And again, part of this is like a difference in legal culture, because the U.S. approach to privacy across the board has been very heavily dependent on this like sort of notice and consent, and we all kind of agree like that's not working because nobody is like reading these long privacy notices, but it's still consent in so many legal contexts in U.S. law becomes like sort of the default problem solver. Like, well, if all else fails, get the person's consent. If they consented to it, then it's all going to be cool. And I just think I suspect that Europeans might more likely rely on some sort of legitimate interest exception in ways that we would feel uncomfortable to solve these just sort of everyday problems where the fact is the data controller is going to have to process and use personal data. And so, again, there's this difference of legal culture.
Well,
that
we're just, I'm thinking about this more, I go back to the technology. If you have a personal health record and it's provided to you by Aetna or by Washington, one of the Washington hospitals, it's protected. If you go online and get it, and it's not sponsored by them, it's not protected. That is a distinction without a difference to the public here. And that's where the kind of holes crop in that we have. And just, I alluded a lot to legislative and policy experience, but the real problem is it takes 12 years to ensure genetic information in only employment and insurance. We can't play whack-a-mole. You have to have something that's more comprehensive and say health data is protected. Now, the real problem is going to be far beyond what we're talking about today is when you start deriving it. What everyone's talked about Target, most of us have read the Duhigg story about Target. That's where it starts to blow my mind a little bit, because now we're not even talking about the data you enter, the data your provider works with. We're talking about something that's derived. And I'm not certain at all how to handle that, except in, again, I'm not looking at saying we should adopt the EU, but I'm saying there's some principles there. The principles of saying appropriate use to what the data was created for. Like I said, I don't think that consumers are going to see a difference just because this is within HIPAA, this is outside of HIPAA. And if we keep playing that whack-a-mole thing, we're never going to stitch in the holes. I think there's some principles we could probably find a way to implement.
Yeah, a stated purpose. I mean, it strikes me it's not that hard that there is a given purpose at the point of creation or collection of a particular set of data. Yeah, we're talking about, as you say, you're using consent or notice and consent. Yeah, we're talking about an actual point at which something is derived, created, entered, handed over, or something like that. That's the point.
And can I ask one question, just sort of to hear like an EU perspective, UK perspective, and just general perspective? Let's say that on Facebook and Google, or let's just make it specific to Google. Let's say that I type in, cough, sneeze, do I have meningitis, or something, on the Google search box. And then I'm signed in, and then they sort of persistently attach that to my account. Should they be able to later use that to serve ads for, say, NyQuil, sinus medicines, etc.? And this gets, I think, to Beatrice's point about sensitive versus non-sensitive. Let's say if I type in stuff about I'm feeling very gloomy and depressed, etc., should it lead to ads for Wellbutrin, Xanax, whatever, anti-anxiety drugs? I mean, does that, in the frameworks that y'all would envision, or that anyone would like to talk about, would you say that this would be something that you'd like to see protected as health data, or you just think, well, that's out there in the big data world, and that's the world we're living in, and it's not protected?
We live in such a bizarre world, you can't advertise like that to the UK. You just couldn't do that.
You couldn't, even for the sinus medicine.
I mean, I've seen ads for aspirin, but you can't advertise directly to the patient, a medicine directly to the patient. That's not the way it works in the UK.
Oh, that's right, yeah. You guys stop it at the DTC.
You can go and give the GP loads of goodies to get them to it.
DTC is allowed to
Right, sorry.
But isn't that
I'll
getting
look
at
the audience.
the
I'm sorry,
business
you were next
versus
to that over
individual?
here.
Exactly.
This is back to our orientation in
Yeah.
the business side. I'm doing a DTC panel next month. It's commercial speech versus the individual.
Right.
And it's another, in addition to context, there's just 3 or 4 things here that are just so fundamentally different. I think they can be reconciled. I don't think you adopt the statute in whole by any means, but they're huge.
But it's so interesting that it focuses on use versus collection and analysis, because that gets to our constitutional point that was just made. Like in a world of IMS versus Sorrell and the First Amendment concerns, I think a lot of privacy regulation is going to focus on use versus collection and analysis because of the First Amendment issues. But it's very interesting. But I'm sorry, please go ahead.
No problem.
Yeah.
So my question is,
back to
what is your experience with the EU cookie law enforcement and with law in general after it came about? And then I'm from part of Europe that is not part of EU, but it's still Europe. So how do you deal with that? I mean, I know that you guys worked with us on protection of, private information, including health information, but how do you enforce that? How does the relationship work?
Which country are you from? I mean, the question
may have just
comes
invited some
spontaneously.
welcome scrutiny.
From Serbia.
Oh, yeah.
Well, with the cookies, I mean, so-called cookie directive, I mean, from 2009, the experience so far has been, there's still a lot of, I would put it this way, there's still a lot of work to be done. It's a directive in implementation. So member states have a deadline, to implement by 2011. Several have not done so, and a question that we often get is like, well, if you now approve a regulation, will that mean that member states should stop implementing, etc.? The answer is no, because the so-called cookie directive, I like to call it e-privacy directive, but it has the same relationship of lex specialis, over lex generalis. So the data protection regulation, it will be the general law. This applies in particular in telecommunication, electronic communications, and will continue to need to be implemented. And for countries, I don't know in particular about Serbia, but I mean most of the countries who gravitate around, I would say, the EU sphere, the most obvious thing to do is to adopt substantial legislations which are not so dissimilar. And this happening in most of candidate countries, for instance, or countries who thought about one day putting candidatures. So you start implementing even before you put your candidature, because that eases your way and makes it easier. Of course, we cannot enforce in a country which is not under EU jurisdiction. I mean, we have no enforcement power in that respect.
Great. Well, I'm really sorry that I think it's my duty to sort of end now because we have the 325 presentation from Dr. Sweeney and on big data and stuff. So with that, please give our panelists a round of applause.